My name is Victoria Echobo. I'm the principal and founder of Crescent's Legal Associates, a law firm based in Abuja and Nasarawa State, specifically dedicated to providing services to landlords and business owners so that they can maximize their income, streamline their operations while staying compliant with the law. In other words, what we do at Crescent's Legal Associates is to help you stay legally compliant while making the best amounts of profits. All right, so in today's session, we are going to be discussing the essential rights every landlord should know. Essential tenant rights every landlord should know. Now, this topic is very important because where your tenant rights begin is where your obligations begin as well. So by knowing what rights your tenant has while being a tenant on your property, you will also know what your obligations are. Because when you know your obligations, everyone will be on the same page. You do yours and they do theirs. Now, where their rights stop is where yours begin. So to every right, there is an obligation. So this is not just about me playing the devil's advocate. I mean, your tenants are not devils though, but this is not about me playing the devil's advocate, but this is about me showing you what your obligations are, so that if you're doing something wrong, you can know. I mean, and some of the things I'm going to share are things that certain landlords do not know. I've always been a landlord's lawyer, right? And I don't remember a time when I served as a tenant's lawyer. I don't know why, but most of the rent recovery matters that I have handled, or this law firm have handled, have been on the side of the landlord. So I know a number of things, and a number of issues that landlords have with their tenants are issues that are ordinarily avoidable. This session is going to be brisk, straight to the point, as my other sessions are, and we are going to be going through this using our templates. So I will be looking away from time to time. This is a copy of our tenancy agreement. Like I always say, this is the same tenancy agreement I use in my business. And we're going to flip through the pages of the tenancy agreement so that you understand the rights of your tenants. Now, your tenants and every tenant has rights provided for in the law as well as in your tenancy agreement. That is why if you are a landlord in 2025, or whenever it is that you're watching this video as a replay or however it is, now you cannot be a landlord without having a tenancy agreement. And not just having a tenancy agreement cut and paste or something you have been using since 2000 or 1990 or 1970. No, you can't be having such things now. You need to upgrade your tenancy agreement. And more importantly, you need to have a tenancy agreement that is drafted and vetted by a lawyer. Not just a lawyer that is experienced in being a Nigerian landlord's lawyer. Alright? So now, what are the rights that your tenant has? Don't go to Google and Google tenant's rights. No, hear this from a lawyer, an experienced landlord's lawyer for that, at that. So let's get on to the business of the day. Now, if you need to get this template, you can click the link in our bio to get this template along with 6 other professionally drafted and lawyer vetted templates. All right, so let's get on. What are the essential rights that your tenant has while being your tenant on your property? And now this is your property, whether it is a rental commercial property or a rental residential property. The first and foremost right that your tenant has while living on or using your property for commercial purposes is the right to exclusive possession of that property. A right to exclusive, undisturbed possession of that property. What this simply means is that your tenant has a right to use that property without your disturbance. I know this may sound scary, all right, because I mean that's your property, and if you don't put your eyes on it, somebody can just spoil it, or somebody can do something that does not augur well. But that is why you need to have regular visits to your property. You need to have regular scheduled visits. So by regular and scheduled, I mean that from time to time, and that's not to say you go there every month or every 2 months or every 3 months. No, you can pick, say, twice in a year to visit your property, or you visit the property when the tenant has issues. Maybe they have maintenance issues, so you or your property manager visits the property to assess, or your workmen to assess what the issue is. When I manage properties for my landlord, I ensure that the tenants have undisturbed possession of that property. But that does not necessarily mean that you don't see it at all. I've explained. You visit, you pay regular scheduled visits. Scheduled means that you give them notice, and usually your tenancy agreement is supposed to state the period, the notice period that you must give your tenant. Oh, I'm coming to the house in 24 hours or in 48 hours. You give them notice that you'll be on the property. Now, having said that, let's go on to the next thing. The first right is the right to exclusive and undisturbed possession of that property. I know a landlord once had this tenant who lived, because the landlord lives within the premises, it was a residential property. Now, because the landlord lives within the premises, the landlord tended to interfere in matters affecting that tenant. So from time to time, this landlord will engage the tenant's family in conversations that, they were personal conversations. There was even a time that the tenant did something and the landlord hung clothes on the line, and the landlord went and cut the rope, that those clothes were too much, other people don't have space. I mean, even if whether you are a mother, you are a father, that is not your role. That is not your relationship with this tenant. Your relationship with this tenant is tenant-landlord, landlord-tenant, and the law requires you to not disturb that tenant. Whatever you want to happen on your property can be stated in the tenancy agreement as well as in house rules. Now, in my business, we have house rules where we need to institute that. So if you are concerned about the use of your property, maybe you've had tenants in the past who did 1 or 2 things on your property that cost you a lot of money, then create house rules. Now, if you want this, along with this tenancy agreement templates, we also have house rules. Now, what are these rules? Right number 2 is the right to keep to the terms of the agreement. Now, when you have a tenancy agreement, when you sign a tenancy agreement with your tenant has a right to you keeping the terms of this agreement. So it is not just enough to sign an agreement or give your tenant an agreement. You are required to keep to the terms of this agreement. You are required to keep to the terms of this agreement. So, whatever is written here should be what you do. If you say that the rent is so amount, then you should not be collecting anything else. If you say the rent is renewable after giving you notice of 3 months and things changed, you also need to give your tenant a notice in advance of the 3 months. In advance of the 3 months. So you cannot just agree on something and then change it and say, no, I'm the owner of the house. I can do, it's my house or it's my property. It's my commercial property. I can do what I like. No, you can't. If there are changes you need to make, if after making the tenancy agreement and there are changes you need to make, the next thing to do, the proper thing to do, is to write them a letter. If you don't know how to write them a letter, or you want to serve your tenants letters and you don't know how to go about it, you need someone to help you to do it, why not send us a DM? And we will gladly take down your brief and write them the proper letters. Now, I have this property manager client who manages luxury properties within the FCT, Abuja. And even though she's managing the properties, when there are communications to send to tenants, whether for eviction purposes or to correct some ideas or to correct a particular situation, she contacts us and pays us to write the letter and deliver same. So we can do so wherever you're located in Nigeria. We can do so. We draft a letter, send for your confirmation or your perusal or your additions if you want to, and then we send that to your tenant. So that is right number 2. Let's go to right number 3. There are a number of them and I want you to pay attention and write. And if you're watching us live, you can always watch the replay because the replay will be there. And if you're watching the replay, make sure to take notes. You can take screenshots and write notes on it, or you just stay till the end and put down your notes somewhere. Right? Of course, you can always come back to this video. Now, right number 3, like I said, I'll be looking away. Right number 3 is the right to know the duration of the tenancy. The right to know the duration of the tenancy. Your tenant has a right to know when the tenancy begins and when it ends. I take that again. Your tenant has a right to know when the tenancy begins and when the tenancy ends. So, if, for instance, at the time of your tenant paying rent, after your screening process and vetting process, now, after the vetting process, you decide that you want to do a few things on the property, your tenant can't move in immediately. You can let the tenant know when the term begins and when it ends. And I usually advise that when you are drafting that clause in your tenancy agreement, make sure to use words like beginning on and ending on, or starting on and ending on, or expiring on. Now, the reason why you do that is to avoid ambiguity, because when you start using words like from or fancy words that are not so clear, you will leave your tenant in doubt. Or you just say things like for a 1-year term beginning on the date of this tenancy agreement. And unfortunately, the tenancy agreement now has 2 dates. A date at the top and a date at the bottom, or a date at the top and a different date that was signed. You know, people who sign and always sign and write dates. So imagine that you have 2 dates. So which date will apply? So it's always best that you specify your tenancy agreement the date that the tenancy begins, beginning on, starting on, and ending on, or expiring on so dates. And if that term is not renewable, say you are letting your property for a 5-year term or a 3-year term renewable to a further term of say 2 years. So let's say you are letting your property for a 5-year term, right, with a 3-year term paid in advance and a further 2-year term paid later at a revised rate. It is important that you state it in your tenancy agreement. Don't leave anything to assumption. I had this client once who was a tenant, and he wanted us to review the tenancy agreement that he was to have with his landlord. And when we took a look at it, we found that there were ambiguities as to when he said that the term was for a 5-year term. And when we inquired further, he said that the first term would be paid for by renovation. The subsequent term will be paid for in cash, right? While the third term will be revised by a certain percentage. A look at that tenancy agreement, I didn't see anything like that. As a landlord or property manager, you need to understand that a document, every tenancy agreement speaks for itself. Every tenancy agreement speaks for itself. You cannot explain additional words to the wordings of a tenancy agreement. So when you write a tenancy agreement or your lawyer writes a tenancy agreement, what is written is what is. What is written is what is. Agreed. It becomes a contract. A court judge takes a look at it, and that's the contract between the two of you. All right? So I hope that explains that. Don't worry if you have any questions. Leave your questions in the question box, or replay, drop your questions in the comment section, and we will attend to it. Now, what other rights does your tenant have? Remember, I said at the beginning that it is important to learn about the rights of your tenants, because where your tenants' rights begin, then there and then do your obligations begin. I take that again. Your obligations to your tenant begins where their right begins. Once their right stops, or where their right stops, your own right begins. That's not to say that the landlord is not important, but that's a fancy way of saying that your tenant's rights begets your obligations, or where there is a right, there is an obligation. So now let's go on to the next right. Your tenant has a right to not have your consent unreasonably withheld. Now, there are certain clauses in a tenancy agreement, including a clause to say not to assign, sublet, underlet, or not to assign, not to part with possession of the property, or not to sublet the property to another person other than yourself. Now, this, unless they get consent from you. Now, that consent should not be unnecessarily withheld. So, unless your tenant is trying to, if your tenant decides to sell his space to somebody else because he has gotten a job out of that location, or he has gotten a better apartment and wants to move there, and then he gets another tenant to take the property, to take a lease of the property, and then he calls on you, oh landlord, I've seen a tenant for this house, please can you take a look at this tenant to vet or go through your screening process. Now, you should not unreasonably withhold your consent unless that tenant is trying to get in somebody that will not comply with your standards. So when that kind of thing happens, what do? You invite the person over, whether to yourself or to your property manager. You invite the person over, or you initiate your screening and vetting process. Once you initiate your screening and vetting process, he or she goes through it. goes through it. If you are satisfied, you go ahead and say, okay, that's fine. Take your rent less so amount, or the person pays to you, and then you give your tenant the part that is not staying, or however it is that will work for you. So your tenant has a right to not have your consent unreasonably withheld. You can't say no, you rented this property, I'm the one to. No, if you those kind of things will not help for a healthy relationship with your tenant. All right, so now let's go on to the next right. Like I said, this session is brisk, is straight to the point, so that you can get on to other things, and we can also do the same. Now, the next right that your tenant has, which for me is the most important right, is the right to a structurally sound and tenantable property. Your tenant has a right to a structurally sound and tenantable property. That is just another way of saying that your tenant has a right to a habitable premises. So whether your tenant is living on the premises or doing business on the premises, as a landlord, as a property manager, your tenant has a right to a habitable premises. So let's say that you've had this property, say, for years, and say you've not been in the country or you've not been in that state, and then you come over and see that your property is in a state, maybe nobody has been occupying it, right? Or say other people other than tenants were occupying it. The tenant who is going to live on that property, or who is going to use that property for business, has a right to ensure that the walls of that house will not fall on them. They have a right to ensure that the sewage will take their what's it called now? Their feces or human waste. They have a right to a tenantable, which is why when you are drafting tenancy agreement, it is very important that you specify who is responsible for maintenance costs. So how that plays out is that you can, in your tenancy agreement, specify that while the tenant is responsible for minor repairs like certain fixtures or repainting after the time that they have stayed, repainting or decoration of the interiors after they have spent some time on the property, the exteriors will now be painted by the landlord. Now, if there's a big crack on the wall that is as a result of the moving of the foundation, I've seen, as a landlord's lawyer, I've seen certain things. So my examples are going to be very practical. Let's say there's a big crack on the wall as a result of the shaking of the foundation. Your tenant has a right to you fixing that crack. Now, if you decide that they should go ahead and do it, then you must be ready to bear the cost. Now, let's say that on your property, your meter, your electric meter, your electric distribution company meter got bad. Your tenant has a right to a replacement of it at your cost. So what I usually advise is that if you cannot go about it fast enough, then you can authorize your tenant to go about it while you bear the cost. So that is right number 4. Yes. So let's go on to the next right. If you have any questions, please drop your questions in the comments below, right? And if you have watched up to this point, I want to give you big thumbs up, especially if you're watching the replay. Big thumbs up to all of you who have stayed up to this point. Let us go to point number 5. Now, right number 5 is a right to notice before eviction. Now, in my work as a lawyer over the past nearly 20 years, I have read many kinds of tenancy agreements. And one thing I have noticed is that landlords, many landlords, and especially property managers, do not pay attention to the eviction clauses in their tenancy agreements. And if your matter has stayed in court, if say you are trying to evict a tenant and the matter has stayed in court for forever, apart from the fact that apart from adjournments by the judge, if you have technical objections and all those kind of, many of those objections come from the eviction clauses. Many times you fall into error with evicting your tenant because you did not pay attention to the eviction clauses. Now, what is an eviction clause? An eviction clause is simply a clause or sets of clauses in your tenancy agreement that specifies how that tenant is to leave your property, how that tenant stops being your tenant. So now, if you don't draft that place properly, if you don't draft those clauses properly, what will happen is that you will give room for the law to take its course. What does that mean? Now, depending on where you are watching this from, there is a law that regulates recovery of premises in all the states in Nigeria. And even if you live abroad and you're watching this, there is a law that guides all the recovery of premises. So, in a state like, say, FCT, I'll give some practical examples. In a state like, say, FCT, the law provides that where there is a tenancy agreement, in the absence of a tenancy agreement, that's how it says. Now, in the absence of a tenancy agreement, when a tenant is to be evicted, those are not the exact words, is entitled, where is a 1-year tenant is entitled to 6 months notice, where is a tenant at will is entitled to 1 week notice, where he's a weekly tenant is entitled to 1 week notice, where he's a monthly tenant is entitled to 1 month's notice. That is what the rent recovery law says for the FCT. Now you come to a state like Nasarawa State. The rent recovery or the recovery of premises law in Nasarawa State, for instance, provides that in the absence of a tenancy agreement, a tenant is allowed to stay on the property for 3 months after his tenancy has expired. What that means is that a tenant enjoys an additional 3 months period if you don't have a tenancy agreement for that tenant. So after his tenancy has expired and he has overstayed, if that overstay is not up to 3 months, because you don't have a tenancy agreement, you are going to have issues. You have to wait until after 3 months. Otherwise, the judge will have nothing else to do than to adjourn or advise you to go and settle with the parties, or will advise the parties to go and settle. So, to avoid those kind of situations, you need to have a comprehensive tenancy agreement. You need to have a comprehensive tenancy agreement. And I tell you, if you pick up these templates that are on the link in my bio, the link in our bio right now, if you pick up these templates, what you will have in your hand, in addition to 6 other professionally drafted documents, will be a comprehensive tenancy agreement. A comprehensive tenancy agreement that captures everything important and relevant to keep your interests safe with respect to your tenant. It also comes with video tutorials on how to use each of those those templates, so that you are not left in the dark as to what to do. You don't just see a document and you see dash. You have explanations on how to use each one. These templates also come with access to a 30-minute video course that shows you the things that you are doing to bring in troublesome tenants to your property. The things that I have done in my business to keep away those kinds of tenants, and exactly how you can begin to do it by yourself on your own. All right, so let's go on. We've talked about the 5th right of your tenant, and now let's go to the 6th right of your tenant. What is the 6th right of your tenant? Because your tenant has a right to notice before eviction, he also has a right to be served all notices. So you have maybe a notice to quit, or a notice of renewal of rent, or a letter. Your tenant has a right to notice of those written communication. So usually what I do and what I advise my clients to do is that they have a clause in their tenancy agreement that specifies how those notices will be served. For instance, let me read a clause here on page 5 of this tenancy agreement. Page 5 says, any notice required to be served herein shall be in writing and may be served personally in the case of the landlord or leaving it at the landlord's premises, and in the case of the tenant, by leaving it at the premises with the tenant's previous found on the property. So what that means is that if you have a letter or a notice and your tenant is not at home at the time, you can drop the letter with somebody that is in the house and make sure that the person acknowledges receipt of that letter. Right? Now, if it is the landlord that the tenant is serving, he can go and drop the letter at the landlord's house. Now, or the landlord's office, right? Now, there are cases where some tenants I have observed, especially those tenants who live in our very big properties, they don't like that interaction at their house. In fact, they don't receive landlord's letters at their house. Prior to their coming onto your property, you need to agree on where to serve them notices. So whether the notices are going to be sent by email or by WhatsApp and copied to email, you have to do that, and at a physical address. So that physical address may not be their office, but they will provide it, and at any time they are changing from that place, they provide it. So you will have to serve that notice. It's advisable to serve that notice in a manner that does not embarrass your client, your tenants. I mean, your tenant is not your client, but it's your tenant, right? So if it is a notice, say a notice to quit, or a notice of increase of rent, a notice of reminder to pay his rent, and you go and paste it at his gate, you are embarrassing him now. Or you go and place it at the door of his flat. No, now. If the flat does not have a space under the door, and it does not have above the door, and it does not have on the side, and there is nobody opening the door, then maybe you find another date. You come back on another date at a time when they are likely to be home. So it's either very early in the morning. I had a property like that once, where at every time I went to that house, there was nobody found. So what I decided to do was that I got to that house by 6 a.m. I got to the house so early that I almost met the tenant in his pajamas or in his boxers. It was like, why did you come in so early? I said, I've been trying to reach you, and I've been trying to get through to you without success. Now, if it is an office premises, of course, you have a receptionist or a front desk or people who receive communication on that property, and you have their phone number. Thank God for messaging apps. You can text them or send them a WhatsApp message or send them a social media message, other social media messages, notifying them of this. And which is why I always recommend that prior to a tenant coming into your property, and even if they have been on your property before you are hearing this, you have a data form, a tenant data form. We have one, for instance, already, and I have one very handy, a tenant data form, something like this, that contains all the details of your tenants, including their email address, their best form of communication, their phone number, their active phone number. You try the number and see that it works, because sometimes some people take a lease on a property without physical encounter, so they must provide their correct information with their next of kin, so that if you can't reach them, you should be able to reach somebody who knows them, or somebody who is close to them, or somebody who can account for them. You also have their guarantor's details, somebody who has guaranteed that if they don't pay rent, that he or she will be ready to do so. You have the guarantor's information. You call the guarantor, I've been calling your tenant, I've tried to reach him, he's not getting through, please get through to the person, because if he does not comply, especially if it is in the case of increase of rent or vacation of the property, I will come and meet you like you have said I could. All right, so that's essentially it. Now let's see, I think we have 2 more rights before we close, and that's the second right is the second to the last right. That should be 7. Now the next right is the right to a signed written agreement. A signed written agreement, because an unsigned document is useless. So if your tenant signs but you don't sign as a landlord, you have issued or given to him or her a useless document. So the reason why you have a signed document is so that it shows what both of you agreed. And usually it's advisable to have your signature on all the pages, so that somebody does not change the page and says that's what we agreed. But of course, your tenants are not those kind of people, I believe. And then finally, your tenant has a right to receipt of payment. Good for you. At Crescent's Legal, we have created all these templates. We have created all these documents as templates. They are the same documents we use in our business. We have receipts, we have a tenant's data form, we have a guarantor's form. In addition to the guarantor's column that is in your tenant's data form, we have a guarantor's form. And that guarantor's form is for added security. We have a comprehensive tenancy agreement, we have letter of offer, we have a bank standing order. Where your tenant is not likely to pay his rent, you have a bank standing order that authorizes payment, automatic payment of your rent. So you don't have to, we also have house rules, whether your house is or your property is a residential or a commercial property. These house rules can be customized to suit the purpose of your property. We have also included individual video tutorials that take you step by step on how to use each template correctly. So you also can access a 30 minutes video tutorial or video course that shows you what, if you are having problems with your tenants, what you are doing to attract those kind of tenants and how to fix it. How we are able to not have those kinds of tenants, and how you can begin to have the same results on your own. All right, so do you have questions? We have come to the end of this session. Do you have questions? Let me know in the comments if you have questions. Let me know in the comments if you have questions. Let me know in the comments if you have questions. Wow. Now, if you have watched this session up to this point, that means that you have gotten value. So I'd like to get your feedback. You have questions, you're watching the replay and you have questions, please drop your questions in the comment section. And you have a feedback, you have gotten a lot of value, please leave a comment below and let us know that we are doing something meaningful. All right, let's know that we're doing something that is impacting you with knowledge. And if you have other topics that you want us to talk about, please also leave a comment and we will address those issues. All right, now remember that at Crescent Legal we are committed to ensuring that landlords and business owners can maximize their income and streamline their business operations using practical legal strategies so that they can enjoy their life without stress. All right, so it's been a pleasure. Thank you so much for being here with us, and I look forward to getting your questions, reading your questions, and please make sure to get the templates by clicking the link in our bio, and I'll see you on the other side.